Hello friends, this is Dr. Sumiti Ahuja, Assistant Professor from Faculty of Law, University of Delhi, throwing light upon the kinds of offer now. To start with, although we have already discussed these two terms here, express offer, implied offer, so I would like to move on to specific offer and general offer. Specific offer, as the name itself suggests, that when you make an offer to a specific, defined, identifiable individual, specific person, that's a specific offer. But what do we mean by general offer then? General offer is an offer which is made to public at large. Now you will think that like a few minutes ago I was mentioning that communication of offer has to be made to the offeree, then the offeree will communicate the acceptance to the offerer. Now if I am making an offer to public at large, to whom I am making the actual offer, with whom I will be entering into contract. Indian Contract Act itself says that in case of general offers, there is no need to, there is no need for communication of acceptance particularly, and even performance of conditions in case of general offers or the offers made to public at large amounts to a valid acceptance. Now what happened, you may understand this concept better through this case law, that is Carlyle versus Carbolic Smokeball Company. Now in this case, Carbolic Smokeball Company had come up with a medicine, it had manufactured a medicine known as Carbolic Smokeball Company, which was there to treat this epidemic of influenza or other diseases which were associated with influenza, related to influenza. Now in the advertisement which they had come up with, the Carbolic Smokeball Company had come up with, whosoever consumed that particular smoke ball as per the prescription would, and as per the frequency also which is stated in the medicine, on the cover of the medicine, will never contract this disease of influenza, or basically it was a prevention to that particular problem which was in existence, epidemic. Now, and this is not just the thing, in that advertisement itself, the company also highlighted that if there would be some person who, despite the fact, has taken that particular medicine as per the prescription and as per the guidance, will not contract influenza, right? But if somebody on the other hand ends up contracting influenza despite having taken that medicine as per the prescription, the company would be rewarding that person with a particular amount of money. I wouldn't say reward, but compensating, right? A particular price would be given to, not ZE price, CE price, a particular amount would be given to that person if that person falls ill. And third thing which that advertisement highlighted was that in order to make their advertisement, in order to authenticate their advertisement, they had mentioned that in a particular bank named Alliance Bank, they had deposited a lump sum of money which they would be using to pay those people who contract influenza despite having taken that medicine, right? Now this lady Carlyle, she read that advertisement, she took the medicine as prescribed, still she contracted influenza. She went to the company, she claimed that amount. Now she is claiming that amount, the company says nothing doing, we never intended to enter into legal relationship, and we did not make any offer to Mrs. Carlyle, and we are not bound to pay anything to Mrs. Carlyle because there was no valid contract in existence. But the court held that the company was bound to pay that particular sum of money to Mrs. Carlyle, which they had promised. They were bound to give that money to her. Why? Because firstly, it was a general offer. It was a general offer. That is, it was made to public at large. But if anyone from the public at large comes forward and performs the conditions of that offer, you will enter into a contract with, you have entered into a contract with that person moment the person has performed the conditions of that offer. So when Carlyle purchased that product, consumed that product as per the prescription, and she contracted influenza, you are bound because contract has come into an existence. Contract had come into an existence and she still suffered from the problem despite having taken medicine. Court held that the company was bound to give her that amount and that there was a valid contract, and that even a general offer is a valid offer, because even though it is made to public at large, someone from the public will act on it. Now, just to add on to it, if now apart from Mrs. Carlyle, there is someone else also who consumes that medicine and contracts influenza. Now, can there be more than one contract in such a situation? The answer is yes. It was a general offer made to public at large. Till the time the company does not remove that advertisement, from public domain, anyone who would, after having consumed that medicine, contracts influenza, company is liable to pay that promised sum of money to that person. Now, next is counter offer. Let me explain it to you through an example briefly. Now, A makes an offer to B saying that, I am willing to sell my house to you for 1 crore. He makes an offer. In return of it, the other person, the party B, states that I am ready to purchase your house, but not in 1 crore, but say 80 lakhs, right? So, is that by communicating this thing that yes, I am ready to purchase your house, but in 80 lakhs, is this an acceptance? Answer is no. It is a counter offer. He made an offer to you that he is willing to sell property in 1 crore. You make a counter offer to him that I am willing to purchase your property in 80 lakhs. So, when a counter offer is made, the previous offer, first offer which had been given earlier, it comes to an end, it becomes void, it is non-existent now. Now, the other concept of cross offer. Cross offer occurs when two parties make similar proposals to each other with neither party aware of the other's offer. In this case, there is no acceptance because both sides are making proposals at the same time and neither has had the opportunity to accept or reject the other's offer. Now, coming to concept of acceptance, defined under section 2b, when the person to whom the proposal is made signifies his assent to, that is communicates his acceptance to the offerer, the proposal is said to be accepted. An acceptance must be in response to an offer. It must be in the mode prescribed, that is if the person who is making an offer to you specifically mentions that the acceptance has to be given in a particular form, particular mode. So, it must be in the mode prescribed. Then it says it must be made by the person to whom the offer has been made, that is communication of acceptance to the offerer. It must be unqualified and unconditional, that is you have to accept the offer as it is, you cannot make changes in the offer, and you have to accept the offer completely. You can't say these terms are acceptable to me, these are not acceptable to me.